Please, I have bad news for everybody. I have bad news.
Oh.
I'm sorry, but I have bad news for you. Okay. Do you remember this quote? I am embarrassed as High Commissioner for this thing to appear on the internet and be a subject matter of discussion in Ghana. I can assure you and Ghanaians that the Ministry of Finance has things well in hand. The creditors are interested in their money and it's not going to be easy selling these properties. So it's not as if tomorrow they are going to evict the Ghana High Commissioner and his staff from his premises, or the High Commissioner from his residence or tenants in Regina House.
This has to do with the judgment debt against Ghana in the UK.
Okay. So you remember that?
Yes.
Okay. Where the 6-story Regina House, which is in central London.
Central London, yes.
Was earmarked for...
It was garnished, yeah.
Okay. Okay. To enforce the 140 million.
Yes.
Okay. So...
And let's be clear, that judgment that arose because of the actions of Godfrey Dami as
So
Attorney
I
General.
have news for you.
Don't tell me they've sold Regina House.
No. A District of Columbia Court in the United States has granted a motion for default judgment in favor of the Ghana Power Generation Company, GPGC, ordering the Ghana government to pay $111 million, $111,493,828.92 plus mandatory post-judgment interest.
Wow.
This ruling follows Ghana's failure to fully comply with an earlier tribunal decision from the United Kingdom. On January 26, 2021, a UK tribunal issued a final award, finding that Ghana breached its contractual obligations by terminating a power purchase agreement with GPGC on February 18, 2018. Ghana had argued that a foreign power company failed to meet certain contractual conditions leading to the contract's termination. However, the tribunal disagreed, awarding GPGC $134,348,661 in damages, calculated based on an early termination payment formula in the purchase agreement. The award included an interest rate of 6-month USD LIBOR plus 6% and reimbursement of GPGC's arbitration fees and expenses totaling $3,309,877.74 with interest at 3-month USD LIBOR, compounded quarterly. Despite the ruling, Ghana only made partial payments totaling $1,897,692.40, leaving a significant outstanding balance. After unsuccessful attempts to secure the remaining payment from Ghana, GPGC filed a case in a U.S. District Court on January 19, 2024, under the New York Convention and Chapter 2 of the Federal Arbitration Act, seeking to recover the compounding debt. Court documents reveal that the U.S. court served Ghana with a petition on January 23, 2024 through Shirley Ayoko-Botchwey, Ghana's Minister for Foreign Affairs and Regional Integration. The documents were delivered in Ghana on January 29, 2024 with a signed confirmation of receipt. However, Ghana failed to respond by the March 29, 2024 deadline. So let me read this again. The documents were delivered in Ghana on January 29, 2024 with a signed confirmation of receipt. However, Ghana failed to respond by the March 29, 2024 deadline and did not appear in the court proceedings. The court determined that it had jurisdiction over the case, citing the New York Convention, which the U.S. has ratified, recognizing UK arbitral awards. The court also noted that Ghana had expressly waived its sovereign immunity and committed to international arbitration under the Power Purchase Agreement. In his August 6, 2024 memorandum opinion, Chief Judge James E. Bosberg emphasized that the arbitral award between the non-U.S. parties arose out of a commercial relationship which falls under the New York Convention. The convention requires that member states recognize and enforce such awards regardless of the party's citizenship or domicile. While the judge did not grant pre-judgment interest to GPGC, they asked for it, he didn't grant that. The court will award post-judgment interest at the rate specified in U.S. codes, adding to the financial burden on Ghana. So there is 111 million US dollars on this particular judgment, this termination, and after the 134 million award in the UK with the Regina House issues, we've only paid 1 point something million. The court documents say that we were served on the 29th of January. We were supposed to respond by March the 9th. We did not respond. And the confirmation of the receipt was also tendered in court. And so please, you can go to my Enjoy Online and you can read this story. U.S. court awards 111 million to Trafigura in judgment debt default against Ghana. So this is the bad news that I have for you.
Randy,
yes,
I think that there's always a right to appeal. And the Attorney General and the Republic of Ghana would get hold of this particular judgment, look at the nature of judgment and the legal matters that has been raised in this particular judgment and make appropriate response in terms of appeal. So it is solely the decision of the Attorney General either to make an appeal or not to make. And as a layman without legal background, I'll leave this matter to the Attorney General.
All right. Okay.
Randy.
Yes.
This is not about being a layman or being an expert.
That's his opinion. You can't take it.
No, I'm also stating mine. I'm not saying that. I'm not referencing. I'm saying that I will comment. It's not about being a layman or being an expert. Because whether I'm a layman or an expert, the fact is that my taxes are going to be used to pay in excess of 140 million.
11.
There's 139 million. And then there's now 111.
I guess it's the same thing.
It's the same thing.
Yes.
Fine. Over 100 million
Yes.
of my taxes.
Dollars
Is going to be used
for wrongful termination.
to pay a judgment debt simply because people who were voted into office chose to be reckless and vindictive in the discharge of their duties. The termination of that contract by Honorable Boachi Ejako made no technical, legal, or common sense. It only made political sense. The decision by the Attorney General, Godfrey Dami, not to even enter appearance in New York when this case was called, speaks to his lack of competence to continue to hold that office. And you can't sit here as a Ghanaian and think that all is well. I mean, what crime have we committed as a country to have voted Haruna and his party into government?
Barbara, Sam, George, you know judgment debts that you have paid in your
This judgment debt just do not arise. It arose because your appointees, your party was reckless because of petty political vindictiveness, because of your petty partisanship. You terminated Trafigura's contract against sound legal technical judgment.
We cannot adduce to that fact. Because
If we cannot adduce to that fact, well, the judgment from the UK tribunal
did not say the government of Ghana was reckless.
It was your recklessness that led to that arbitrary.
This is his opinion. The judgment did not say the government of Ghana was reckless.
No, it was wrongful termination. That was a decision of.
But the government of
But wrongful termination is reckless.
So just listen to this. So Dennis Asare, a senior research associate at Imani Africa, told the Africa Report that given how much debt the energy sector is saddled with, this 140 million, this is when we lost the arbitration. This 140 million US dollars award is a lot of money. The whole situation could have been avoided because the contract termination wasn't carefully thought through. It could have been deferred rather than prematurely cancelled. It says there was no basis for the termination of the contract and blamed ill advice from the Attorney General's department for the imprudent decision.
Randy, I still maintain I am not privy and I don't have the full facts on that particular agreement. But I don't think that the judgment as it's been issued talked about government being reckless on this matter. And we all know the history of judgment debts in this country, when even ministers have to come and even justify some of this particular payment. So we need to look at it as holistically as a nation. And that's why I have deferred this discussion on this judgment debt matter to the Attorney General.
But the facts,
will be able
the facts of the case really are that the government of Ghana terminated a contract in 2018.
Maybe they had a reason of determination.
I'm saying, I mean, everybody has a reason. Whether the reason is noble or not is what is the issue. But everybody has a reason.
Oh.
The reason could be sound or whatever. So we terminated the contract. The company went to arbitration. Ghana was represented at arbitration. At the end of the day, the arbitration found that the termination was wrongful. So they awarded them. And Ghana had to pay about 140 million. So they even, because we weren't paying, they attached our property in England, the Regina House, the 6-story thing. Then we went to negotiate. And then we paid 1-point-something million. So we committed to paying. We paid 1-point-something million. And then that's it. Now, the people have gone under the UN Convention to a US district court. The court documents say that we were served through our foreign minister, and that the confirmation of the receipt was also produced in court. In Ghana, it will be proof of service.
Proof of service.
Yes, was brought to court. We were served January 29th. We were supposed to make an appearance by March 9th. We did not. So this August, I think about 2 weeks ago, the judge then has made given his ruling on the matter. So these are the facts.
The side of the story. Because we need to hear the Ghana side.
This is the report from the court, what has transpired.
I agree. Yes. But that is the side of the court,
yes.
What they are putting to us. We have not heard the side of Ghana,
yes.
In terms of representation.
Yes.
So that is why I am careful with regards to this particular discussion. The side...
So I want to even hear two things. One, how come we have not taken steps? First of all, the issue of the wrongful termination. I think that maybe another day that issue will come as to whether we should hold people responsible for that decision or not. The decision which is going to cost us in excess of $130 million. Whether those who took the decision should be held to account or not. That for me is another issue. Now, having lost and the arbitral award made, why haven't we taken steps? Even when the people tried to garnish the High Commission's property. And that is why I referred to the interview that my High Commissioner, Papa Osuankuma, granted Joy when the issue occurred. Okay. And it is this non-compliance to the arbitral award which has led the company to now go to a U.S. district court. Is it true that our Minister of Foreign Affairs received it? Why weren't we there? Why haven't we taken steps to make the payment? Because there are many payments that we have made to people. There are some that we were even discussing a few minutes ago. But the truth of the matter is that there is over $100 million that this country has to go and pay.
That's a fact. But the court said that the foreign minister was served. We have not heard from the foreign minister. We have not heard from the Attorney General, whether this is actually true or not. Remember, this judgment is given in absentia because we are not part of the judgment. We have not appeared, right, from what you are saying.
But the truth is that even without this judgment, the arbitral award, which was made in the UK, is binding on us. In fact, we have paid 1-point-something million out of it. Yes, and we know that the High Commission's property was garnished earlier. What if they even go back and go and enforce that again?
And that's why I'm saying that now that this judgment too is also out, I believe that let's give the opportunity to the Attorney General.
Why must we be saddled with something like this just because some people decided to use their pens wrongly?
Randy, you see, and here, Harun, I speak to you as a brother. I know you're the Deputy General Secretary of your party, and so you find it hard to be critical of your party. But as a young man, we're young people. We need to come to that place where we say to ourselves that this is about our country. Look, the actions of Boakye Agyarko on the advice of the Attorney General's Department to terminate this contract is what has led us here. It's been established in a court of law or an arbitrary court at arbitration with Godfrey Dame present as Attorney General, because this arbitration happened when he became Attorney General, that we wrongfully
But not to confirm he was part of the arbitration. Somebody else could have represented him. So arbitration was done. Fact.
Stop trying to defend. You see,
arbitration was done.
Listen,
but whether Godfred was there or
Ghana
not,
was represented.
Period. But whether Godfred was present or not,
whoever went there.
so arbitration was done.
Listen. Let me tell you something. In the maritime dispute, that Marietta did all the work. Who went and stood there and said they got credit? Is it not the then Attorney General and Godfrey who went to stand there?
Because he was there in the court. But in this
they went to the court.
Not
at the time they went to the court, the arguments had been completed by Marietta. So,
but
you see,
Godfrey has led so many arguments.
When you take credits for the actions of the office, you can't run away from issues when they arise in that office. Whether Godfrey was present personally or not, whoever was there was his representative and acted in his authority.
This is what I want to say, but not Godfrey.
So don't stop defending Godfrey, because you can't defend him. He has no reputation to defend.
No.
Oh, Sam.
Listen,
you can't confirm. You can't confirm whether Godfrey was there.
He has established this to all Ghanaians. An Attorney General who tries to quote.
I say exceptions to that because
let's deal specifically with this issue. I think you need to withdraw that. It's very unfair.
With the greatest of respect to you,
yes.
If you find it unfair, that's fine. I withdraw it.
Okay.
But Randy, I hold the view that Godfrey does not clothe himself in glory.
Let's stick to this issue.
I am on this issue. Even on this issue. Godfrey, yes, on this issue. The Attorney General, Godfrey Dame, has not clothed himself in glory because he went into arbitration and lost woefully. And we got a judgment of 130.
He was dragged into arbitration.
Yes, he was dragged into arbitration and lost woefully. 130 million plus US dollars has been slapped on your children and my children.
Which children? It's in your lifetime. Which children?
No, Randy, we won't finish paying though.
Oh, you will pay. You think that the company will wait for your children to pay?
Even if we pay it, we'll go and take a loan that our children will come and pay.
Anyway.
So the thing is, we must be concerned about the country that we are building. And there are times where we must say, look, on this one, it is wrong. The question we should ask ourselves is, why is it that when these people now took us to the New York court, the District of Columbia court, they served Ghana?
They said they served us. We haven't confirmed
not that they said they served us. You see,
well, that's what the document says.
Haruna,
but
Haruna, are you disputing?
Let's leave space.
No, because we need to get the confirmation whether we were served.
We've seen things in this world.
We can't assume that we are actually being served.
My point is that
you see, when he says that we've heard their side, and we are yet to hear Ghana's side, Ghana had the opportunity to have its side heard.
That is
in the court.
They did not
and
go.
They failed to go.
Period.
Is that not the reliction of duty?
Fact. It's a fact. But the point is that
you agree with me that
because that's what the judgment said.
Exactly.
That we did not.
Because Randy, I do not believe. And Randy, look, U.S. judges are not themselves.
You know what?
U.S. judges themselves are not. You understand me? But
what I find quite interesting about this judgment. You know, they asked for some pre-judgment,
yeah. The court set aside.
However, the judgment now includes post-judgment.
Post-judgment, yeah. Compounded
quarterly.
Yeah.
If we continue with
the longer we stay,
the attitude, what it means is that this thing could end up getting somewhere. Why did we do this?
Randy,
why did we have to saddle ourselves?
Even when the arbitration cost was given, award was given in London, there were experts in the industry who said, look, if our authorities would just eat the humble pie and reach out to Trafigura and say, look, let's cut our losses, let's negotiate. Yes, there's a judgment debt of over 130 million. We can't. So can we sit down and agree on something? What have been your legal fees? What is an amicable settlement we can reach out to even drop it? But the arrogance of the people in power, Haruna, the arrogance of your people, the haughtiness with which they conduct business will not bring them to accept the fact that they are incompetent at best and criminally liable at worst.
No.
They would lord their incompetence over everybody. and drag this nation down a ditch. And I think that young people in your party must begin to speak up against the leadership of your party that is mortgaging the future of young people like you in your party. Because the time is coming when nobody will want to give credit to anybody from your political tradition because of the mismanagement, because of the abysmal performance, the callousness of Nado Bawumia and the leadership.